On this episode of Law Weekly, we feature a conversation about the welfare of magistrates and customary court judges. We have the views of a former chairman of the Ikorodu branch of the Nigerian Bar Association and convener Citizen Support for Lower Courts, Mr. Bayo Akinlade. Also showing on the program, the Attorney General of the Federation and Minister of Justice, Abubakar Malami, SAN, has been speaking about deductions from the Pari Club reforms, the convictions secured on terrorism, and other issues, plus a recap of the top trending legal stories. Hello and welcome to the program. I'm Shola Sheyeli. My guest, Bayo Akinlade, is the past chairman of the Ikorodu branch of the Nigerian Bar Association. He's been involved in many initiatives in support of an independent judiciary. A few years ago, he founded the Fight Against Corruption in the Judiciary, and through that work, he's identified that the lower courts were perceived by many as the most corrupt and ineffective in terms of justice delivery. And that's the starting point of my conversation with him.
Well, for a few years, I've been involved in fighting corruption in the judiciary, and in that process, was exposed to a lot of fundamental problems with the judiciary. And interestingly, most of the complaints came from the lower courts. And where a lot of people complain that corruption is well embedded in the magistrate court, I began to look at why this is the case. And that was why we established a followership to look into the welfare, critically look into the welfare of customary court judges and magistrate court. And interestingly, we found that very troubling information, especially concerning their salary structures and their workspace environment. So a lot of this. And they were obviously exposed to a lot of situations that will make them compromise. So that's why we began to say, let's expose some of these things. And these lawyers that are magistrates and these lawyers that are customary court presidents, this is what they're actually going through.
So tell us about some of this troubling information that you said.
Well, I discovered that when you come into the magistrate, as a young lawyer, the level at which you come in, most lawyers will come in at their third year at the bar. Some even come in later, maybe 10 years or even 15 years have been known to come into the magistracy. First of all, they don't even know what their salary is going to look like when they are applying to be magistrates. Now, when they get the job or when they get appointed, you find a situation where they are offered maybe 150,000 naira per month.
Are you saying that there's no clear-cut salary structure?
Not that I have discovered so far. I've tried to inquire, but when I speak to a lot of magistrates, both Lagos and outside, many of them are not even aware of what their salaries are going to look like, not until they get appointed. And when they get appointed, of course, they now see what it looks like, and their take-home pay averagely when they start is about 150,000, less than 200,000 after tax and all other things like that. So you have a situation where even if they do their job for 3 months or 1 year, and after a year, what is 150,000? What is even 200,000 for a lawyer who has come out of practice with all that kind of experience and has to do all these cases on a daily basis, and the cases are much. You have as much as 30 cases per day for an average magistrate. You are doing all that work, and then your take-home pay is less than 200,000. So it's kind of ridiculous, if you ask me.
When you say that magistrates hear as much as 30 cases a day, because I was looking at a recent write-up you authored where you said that about 70% of all legal cases are handled by lower courts in Nigeria.
When you look at all the statistics of who has disputes, basically, and these are people that are under the the poverty line. They're just lower class, middle class people. And interestingly, when you take a look at the statistics, obviously, most Nigerians are in that bracket of we now even have lower middle class. So all these cases are being handled at that level, either in the customary courts or in the magistrate courts. Almost every criminal case starts in the magistrate court. Only felonies, move up to go to a high court, and very few, like the financial crimes cases, can go straight to federal high court or high court. But even some of those financial cases also can start at the magistrate court. For Lagos, for instance, the limit is 10 million naira. So anything below 10 million naira can come to a magistrate court. So when you look at those statistics and then you look at the civil cases, nearly all tenancy cases can be heard in the magistrate court. Simple contract cases can be heard at the magistrate court. Traffic offences in the magistrate court. So when you look at the disputes of everyday life, you see that the magistrate court has most of the burden to decide between individuals, between families, between friends. So we have a lot of cases at this level. For the customary court judge, you can imagine every customary case that has to do with tribe, religion, small offenses, environmental offenses in the local government. These are the people who sit down to hear those cases. So very, very few cases actually are heard at the high courts or at the federal high courts level. So when one looks at it, really, a bulk of dispute resolution mechanism starts with the magistrate courts, and most of them end in the magistrate courts as well.
They handle the bulk of these cases. You say 10 to 30 matters a day, and they sit for 4 to 8 hours a day without taking a break. And yet they're the most poorly paid. That is very disturbing.
Yes, it is, because the state governments are not paying attention to, first of all, their needs. Now, it's another thing that really upsets me is that the state government is generating a lot of money from these courts. Ought not to be, but that's how it is. Now, if you're generating so much from these courts, why don't you take time to pay attention to the needs of the magistrates and the customary court judges?
For those who don't know, tell us how the government generates money from the courts.
Well, traffic offenses for once, the mobile courts, environmental courts, and like I said, the traffic court. So, all these people that are found guilty, you find minimum of 10,000, 20,000 naira being paid to the government coffers when a magistrate decides on whether somebody has committed a traffic offense or an environmental offense. So, and of course, we pay court fees, and all these court fees, most of it go to the government. There's also the probate registry, although those ones are the high court. But at the magistrate court level, yes, there is a lot of income being generated from the magistrate court. And it's very unfortunate that these magistrates across the nation, they're lawyers, professionals. Their expertise is very, very vital to the judicial system. And judiciary, being the third arm of government, cannot afford to be neglected to the extent where a magistrate is being paid such a small amount that what the economy says out there is forcing them to now take bribes or forcing them to compromise their situation. So when we started looking at the fight against corruption in judiciary, we had two things to deal with. We had the actual taking of the bribe and then dereliction of duty. So you find that a lot of magistrates who do not take bribe are also not happy doing the job they're doing, which means that if they have to sit 5 times a week, they might have conditions at home or health issues that will not allow them to sit 5 times a week. And if they don't sit when they're supposed to sit, it means that justice is delayed. And there's so many things that happen when somebody cannot access the justice system. It can only get worse, it doesn't get better.
So what's the solution as you see it?
The solution is simple. We've seen now that the federal government has now looked at increasing the salaries of judges of a higher court bench. Now, this is the time for the state governors to start looking at it and say, if you have Supreme Court justices coming publicly to say oh, we're not earning enough. Imagine what the lower courts are going through. They're saying they've not had a salary review in 7 years. What about the magistrate court? When was their last salary review? So when you look at all these indices, it's time for the state government, it's time for the National State House of Assemblies to start looking critically and say, okay, if this has happened from Supreme Court justices and the higher courts, what is going on with the lower courts? Lower courts is the most vital court.
Because it's closest to the
It's
people,
the closest to the
it has
people.
more of the bulk of the cases.
Exactly. Unfortunately for them, they also have a bureaucratic structure, or a structure within a structure. So you find a situation where the magistrates, a lot of them know these problems, and a lot of them in the past has even risen up to fight the powers that be. But what happens is that because they are being treated like civil servants, they don't get promotions. So a lot of magistrates now just stick with the job or find a way out. So it's very difficult for any of them to stick their neck out, or for the Magistracy Association to even say they want to do anything, because they're not even respected as a class of judges, or even a class of lawyers, and that worries me a lot. The magistracy is seen as a civil service structure.
Because I find that it's an anomaly when you say that magistrates and customary court judges are not part of the bench, even though there's judges in the name customary court judges.
They are not part of the bench per se. They're just, they are mostly treated like civil servants. Same way with magistrates, they have this connotation, they say they are not judicial officers. And as far as I'm concerned, they are judicial officers. Whether they are, exactly, whether they are magistrates, whether they call them judges, it doesn't matter what they call them, but what they are is very important. And if they're not treated in terms of what they are and the job they are doing, the justice system is just going to continue to sink further down, and there's no rescuing it if it completely collapses. Now it's time for the state government to take on their responsibility for the magistrates and the customary court judges. You cannot leave them in the situation they are in right now, because if you do, we will continue to compromise the judicial system. And everybody has complained already that all the corruption, most of the corruption is from the magistrate court or from the lower courts. So why don't you just take out the causes or the fundamental causes of this corruption, which is inadequate salaries, bad infrastructure, bad working environment. Take those out of the equation and see whether or not there will be an increase in service delivery from the magistrate court level, and reduce the level of corruption that we have currently.
As a group, Citizen Support for Lower Courts, are you going to be lobbying the state lawmakers and the government to give this issue the urgent attention that it deserves?
Yes. Oh yes, and the group is quite interesting, because what I've done is invited more of the families of magistrates and customary court presidents, because they are the ones suffering, the backlash from their breadwinner not being able to come home with something substantial. I mean, look at it, for instance. The average magistrate that decides on a contract, or can decide on a tenancy matter, or can decide on a business relationship, or can decide on the freedom or otherwise of an individual in a criminal case, can go home without security, has to probably enter a public transport. It's very unfortunate that a person that decides these substantive issues of life is not protected in any form in the work that they do. So it's something that concerns a lot of us. If their families are not doing well, how do you expect them to sit in court and judge fairly between parties? Through the legal community, through the MBA, and through community platforms, what I've invited people. Are you relatives of somebody that works as a magistrate or a customary court judge? Do you know them? Are they your friends? Are they your neighbors? Let's come together, join the platform, talk about the challenges you face. Because those people know them in their communities, those people interact with them, their family members know. There's a lot of pressure on people with title in this country. So when you call somebody a magistrate or a president of a customary court, the society looks at you like you're wealthy and you're able to solve their problems. But the reality is that they are not equipped to solve people's problems because they don't even have provisions to even solve their own problems. So it's important that we bring everybody that knows them and close to them and say, come, you know what, this is time we need to start lobbying. We're not going to go by way of court, but we're going to go by way of lobbying the powers that be. These things can be done easily. It's just the government making the right laws, putting the right machineries in place, allocating the funds properly.
Welcome back. The Attorney General of the Federation and Minister for Justice, Abubakar Malami, SAN, has been speaking about deductions from the Pari Club refunds and the controversy it's generating.
It was the Governors Forum and not the federal government in the first place that engaged the consultant. 2, when eventually successes were recorded associated with the refund associated with Paris Club, the governors, collectively and individually, presented a request to the federal government for refund. And among the components of the claim presented for the consideration of the federal government was a component relating to the payment of these consultants that are now constituting the subject of contention. When the claims were eventually processed and paid to the to the Governors Forum, they indeed on their own, without the intervention of the federal government, took steps to make part payment to the consultants, acknowledging their liability over same. And then 4 or 5, when eventually they made such payments, at a point they took a decision to stop the payment. The consultants instituted an action in court against the Governors Forum. And what happened in court? They submitted to consent judgment. Thereafter, the federal government, under the administration of President Muhammadu Buhari, was requested to comply with the judgment and effect payment. The president passed on the request of the governors to the Office of the Attorney General for consideration. And I am happy to report to you that the governors individually and collectively provided the desired indemnity to the Office of the Attorney General, conceding, agreeing, and submitting that the payment should be made. And yes, and that was the basis and the ground on the basis of which we eventually took a decision advising the president that the payment should be made. And then along the line, there was a change of leadership of the Governors Forum. And all the noise making that is now being generated arising from the Governors Forum is not only unjustified, but indeed a clear case of indeed absence of defense.
The AGF also spoke about the convictions secured on terrorism.
We have so far, as a ministry, secured over 1,000 convictions on terrorism. For your information, Nigeria is not operating alone in the fight against terrorism, anti-corruption programs, and associated things. And it is only logical that information and intelligence reports have been shared. The idea of remaining analog and manual in operations, we felt, is not good enough for the system as it relates to international engagement. So we have now succeeded in putting in place a technologically based case management update arrangement, which will now enable us to respond rapidly and speedily to international inquiries arising from our international engagement responsibilities on mutual legal assistance, among others.
Here's what the AGF had to say about the organ harvesting case involving former Deputy Senate President, Senator Ike Ekweremadu.
If indeed a crime allegation is an issue, the jurisdiction determines what happens, both in terms of request, in terms of support, and not for a Nigerian government to simply, because you are high-profile personality, jump into the arena. It has never been the tradition of Nigerian government to interfere on anything judicial, local or international, and that stands the position of the government.
In other news, human rights lawyer and senior advocate of Nigeria, Femi Falana, has been speaking about the continued detention of human rights activist Inebeyi Effiong for alleged contempt. Here's the report.
Constitutional lawyer and senior advocate of Nigeria, Mr. Femi Falana, has vowed to sue officials of the Akwa Ibom Correctional Service for inflicting torture on human rights lawyer Inebeyi Effiong. In a statement made available to Law Weekly, Mr. Falana pointed out that contrary to the provision of Section 2 of the Anti-Torture Act of 2017, the penalty for the offense of inflicting torture on any person in Nigeria is 25 years imprisonment without any option of fine. The statement reads in part, "The brutal torture meted out to Inebeyi by the prison officials in Akwa Ibom State constitutes a violent violation of his fundamental right to dignity guaranteed by Section 34 of the Constitution of the Federal Republic of Nigeria, 1999, and Article 5 of the African Charter on Human and People's Rights." The Chief Judge of Akwa Ibom State, Justice Ekaite Obot, had on July the 27th committed Mr. Inebeyi Effiong to the State Correctional Center for 1 month over what she described as confrontational and contemptuous behavior in court. However, the warrant signed by the judge directed that Effiong be held in Ikotekpene Correctional Center, Akwa Ibom, throughout the duration of his prison term. But the order of the court was secretly varied as Inebeyi was forcefully transferred to Uyo Correctional Center in handcuffs, even though there was no violence on his part. The statement reads further, at the Uyo Correctional Center, Inebeyi was forced to sit on the bare floor while his head was shaved together with his beard. He was thereafter subjected to more horrendous humiliation and paraded before all prison inmates. Last week, the president of the Nigerian Bar Association, Olumide Akpata, had said that the NBA may consider reporting the Chief Judge of Akwa Ibom State to the National Judicial Council over the incident.
It's still a developing story, and we'll keep you updated when we know more. On the home stretch, let's now bring you a recap of some of the top trending legal stories.
We begin with the report that the governor of Rivers State, Nyesom Wike, has denied filing a suit against the presidential candidate of the People's Democratic Party, Mr. Atiku Abubakar, the governor of Sokoto State, Aminu Tambuwa, and the PDP over the conduct of the presidential primary of the party that was held in Abuja on the 28th and 29th of May 2022. Wike, who described the news as fake, instead accused Alhaji Atiku Abubakar of being behind reports that he filed a lawsuit. The suit, which was filed at the Federal High Court, seeks, among other things, a declaration on whether the purported transfer of Mr. Tambuwa's vote to Atiku by the PDP was legal. The plaintiffs are also asking the court to reject or remove Atiku from its list of candidates for the 2023 presidential election and an order recognizing Wike as the winner of the primary, or an order directing the PDP to recount the votes of the primary that held on May the 28th and the 29th, 2022. No date has been fixed for hearing of the suit. At the same Federal High Court in Abuja, Justice Ahmed Mohammed has fixed September the 7th for hearing in a suit seeking the disqualification of Bola Ahmed Tinubu, presidential candidate of the All Progressives Congress, from contesting the 2023 presidential election for allegedly presenting forged certificate. The court fixed the hearing and also granted an ex parte order for substituted service on Tinubu, who was said to have evaded personal service of court processes. The plaintiffs, who are 4 chieftains of the All Progressives Congress, are also asking the court for an order disqualifying Tinubu from contesting or participating in the forthcoming 2023 presidential election on the grounds of the information he supplied to the Independent National Electoral Commission, INEC, as presidential candidate of the party. The suspended Accountant General of the Federation, Ahmed Idris, and 3 others have asked the Economic and Financial Crimes Commission, EFCC, to arrange a plea bargain in their trial for an alleged 109 billion naira fraud. The EFCC's lead prosecutor, Senior Advocate of Nigeria, Rotimi Jacobs, said the suspended Accountant General reached out to him through a third party for a meeting to work on the plea bargain arrangement. And we round off with the report that the Federal High Court sitting in Abuja has declared as illegal and invalid the unilateral amendment of the Rules of Professional Conduct (RPC) for legal practitioners in Nigeria by the Attorney General of the Federation, AGF. Justice Donatus Okorowo, who dismissed the preliminary objections filed by the AGF, held that the General Council of the Bar, which has the authority to amend the rules, is constituted by several members, and as such, the rules cannot be legitimately amended by the singular desire and action of an individual. The AGF was reported to have said the amendment was made in the exercise of the powers conferred on him by Section 12, subsection 4 of the Legal Practitioners Act as Attorney General of the Federation and Minister of Justice and President of the General Council of the Bar.
That's the program this week. Don't forget that you can find this episode and past episodes on our YouTube page. I am Shola Sheyeli. Thank you for watching.